Now we're going to become a little more somber, but I don't think so. Our group with us today is quite lively, and actually we're really excited to present to you about statutory interpretation. We entitled our group, "Does Plain Meaning Always Mean Plain Meaning? A Deeper Dive into Statutory Interpretation." Now we will provide, we're going to begin with some basics, and you'll see as we go through the panel, you're going to get a judicial attorney's basic viewpoint of statutory interpretation. Then we're going to be moving on to a civil attorney, doing a deeper dive, and then criminal attorneys, assistant public defender, and assistant prosecutor from Cuyahoga County. And then to wrap up the session is we're going to get yet into a deeper dive with Andrew Paulus, professor here at Case Law. So there is a progression, and I really do think they're going to keep your attention, even though some of you may think the topic is a little dry or detailed. But the first section is, again, Romy Daher from the 8th District will be presenting. The second one is We're All Textualists Now, a brief overview of the trend towards a rejection of legislation history and administrative agency deference in statutory interpretation, presented by Colleen Mountcastle from Burns White. And then we have Dan Van, an assistant county prosecutor, and Erica Cunliffe as an assistant county public defender's office, followed by An Inconvenient Truth. Practical realities sometimes defeat plain meaning. With that, I'm going to turn it over to Romy Daher.
Thank you, Judge Boyle. Like Judge Boyle said, our discussion today focuses on plain meaning. And what you guys are going to find out is that plain meaning isn't always so plain. So I'm going to start off by discussing the basics of plain meaning. The term plain meaning, it's also known as ordinary meaning, clear text, and unambiguous language. This has been with us for decades. And in Ohio, we use the plain meaning approach, which means that we first look to the statute's language, giving the words their plain and unambiguous ordinary meaning. And then only when the statute is ambiguous do we then look to otherwise relevant information. Otherwise relevant information. Now that was my basic definition. This is how the Supreme Court defines it. So this was a case back from 1902, and in that case, the Ohio Supreme Court stated that when you're looking into statutory construction, you need to give effect to the intent of the lawmaking body that enacted it. And when its provisions are ambiguous and its meaning is doubtful, that's when you then look to the history of legislation and the consequences of a literal interpretation, etc. But the intent of the lawmakers is always sought first. And if the words are free from ambiguity, then there is no occasion to resort to other means. So the question is not what did the General Assembly intend to act, but what is the meaning of that which it did enact? That body should be held to mean what it has plainly expressed, and hence no room is left for construction. So what does this all mean? The Ohio Supreme Court has addressed plain meaning and statutory interpretation questions time and time again, and with each time this basic definition underlies the court's analysis. For example, in a 2017 case, the Ohio Supreme Court stated, when a statute is unambiguous, it is to be applied, not interpreted. There is no need to look into legislative intent, legislative history, the consequences of interpretation, or any other factors. And they're identified in RC section 1.49, but we'll get to that a little bit later. And in 2009, Ohio Supreme Court stated, where a statute definition is plain and unambiguous, the court's analysis is limited to applying the legislature's enactment and giving effect to its plain meaning. So what is the bottom line? The basic concept of the plain meaning rule is that if the text's meaning is plain, then other information can't be considered. If it isn't plain, then other information comes in, such as legislative history, practical consequences, the statute's title, etc. Now, there's something interesting to note about the plain meaning rule. There is an exception. Ohio recognizes the absurdity doctrine as an exception to the plain meaning rule. And this applies when the plain language of the statute would lead to an absurd or unreasonable result. And that was in State versus White. Now, this exception is premised on a guiding principle of statutory construction, which is that when the General Assembly enacts a statute, it does not intend to produce an absurd result. And that's in RC 1.47C. The Supreme Court, however, has cautioned that all courts should exercise restraint in using this exception and only using it in cases in which the plain language of the statute would result in an obviously unintended result. And that is because when this exception is used, it entails the imputation of legislative intent based on the judge's perception, and it vastly expands the court's authority. I wanted to share the White case with you because I found it interesting in the context of the absurdity doctrine. Now, in this case, a former police officer, Thomas White, was convicted of felonious assault with a firearms spec, resulting from the shooting of an individual during a traffic stop. And he was sentenced to 7 years in prison. This was a jury trial. And then he got 3 years for the firearms spec, which was served consecutively. So he got 10 years. So he appealed, and the 6th District found that the specification, the firearm specification that's in RC 2941.145, couldn't be applied to him because he was an officer and he's authorized to carry a firearm and he didn't use it to facilitate the offense. So the appeals court reversed his conviction and remanded it for new trial. Well, the state appealed to the Supreme Court and argued that the General Assembly didn't provide an exception for police officers in this statute. And the state's argument was twofold, and it was based on constitutional grounds. According to the state, the legislature had a rational basis to deter all criminals, whether they were police officers or not criminals, but all offenders, from using a firearm, whether they were police officers or a member from the criminal world. And even if his duties required him to carry a firearm, those duties didn't require him to discharge it. So when he did, it wasn't a legitimate act of law. So just as an aside, this is the statute that's at question, is the firearms spec. And it says that you have, there's a 3-year mandatory prison term for offenses committed when the offender has a firearm on their person or under their control while they're committing an offense, and relevant to this case, and it was used to facilitate the offense. Now, the White Court didn't get to the constitutionality issue. They resolved the issue through statutory interpretation. And they said that the state's view would lead to an absurd result. They declined to apply the spec to the police officer because doing so would not have been reasonable or just given his obligations. The court reasoned, given the need for hurried judgments without the chance for reflection, and given the extensive training that causes officers to act reflexively when encountering these potentially dangerous situations, it is neither just nor reasonable to apply a firearm specification to an officer involved in an on-duty shooting just based on a showing of poor judgment or negligence. Therefore, the court concluded that the General Assembly did not intend the firearm specification to apply to the police officer in this instance who fired a gun when he thought that the person was about to brandish a weapon. In those circumstances, it can't be said that the officer's use of the firearm was used in an attempt to facilitate the offense, and that the statute requires a distinction be drawn between a police officer who acts in accord with duty to uphold the law and one who abandons it by committing a criminal offense. Now on to some statutory things to remember. So section 1.1 through 1.65 of chapter 1 of the Ohio Revised Code govern the rules of construction. And what you're going to find is that in all these plain meaning cases, courts refer to either like section 1.47 or 1.49. And as I mentioned earlier, 1.47C states that when enacting a statute, it is presumed that a just and reasonable result is intended. And then 1.49, in this section, the General Assembly gives us some guidance on what to look at when a statute is ambiguous. And it provides that the court, in determining the intention, may consider, among other matters, such as the object sought, the circumstances under which the statute was enacted, legislative history, the common law or former statutory provision, the consequences of construction, and the administrative construction of the statute. Thank you. This concludes my portion of the presentation, and now on to colleague.
Morning, everybody. I'm going to talk about some trends in statutory interpretation, and I'm first going to take issue with Judge Boyle suggesting that this is a dry topic. Exciting. I'm going to also take an opportunity to publicly thank Justice Sharon Kennedy for having the good sense of citing to a YouTube video in her Maple Heights versus Netflix case. It not only gave me the theme of today's discussion, but it also gave me the opportunity to constantly refer to Justice Kagan and her words on textualism so that you don't have to hear me talk as long. So with respect to the Maple Heights case, I will tell you I had no involvement in the case. I knew nothing about the statute at issue, but when Judge Boyle gave us this topic, I wanted to see what was out there in terms of recent statutory interpretation cases at the Ohio Supreme Court. And it came across a very strongly worded concurring opinion by Justice Kennedy. And in her concurring opinion in the Maple Heights case, she really took issue with the city suggesting that there was an implied right of action in a statute that was at issue in the Maple Heights case. So I'm not going to get into details at all about any of the cases that I'm going to be referencing. I'm really going to be focusing on the statutory interpretation discussions within those cases. And so when Justice Kennedy addressed the city's argument, it was very clear that she was less than pleased that they were suggesting that there was something other than the text that the court should look at when performing the statutory interpretation in the Maple Heights case. And that's when she referenced Justice Elena Kagan's somewhat famous quote of, "We're all textualists now." And so I'm going to turn it over to Justice Kagan, where she makes that statement that is often quoted by others as well.
I really do mean pretty much for everybody. Here there's that classic phrase, we're all realists now. Well, I think we're all textualists now in a way that just, was not remotely true.
In the longer interview with Justice Kagan, it's interesting that you have a justice who clearly has ideology that is far different from the late Justice Antonin Scalia. But she did talk about how Justice Scalia has had quite an influence on courts in terms of how they approach statutory interpretation. And I would suggest, just in terms of looking at some of the recent Ohio Supreme Court cases on this issue, textualism is a theme that I've seen in recent cases. And so I believe that from the United States Supreme Court now to our state Supreme Court, we are seeing a trend towards, when a statute is being looked at, the court is first going to look at the text of the statute. I know that seems obvious, and we as practitioners need to be mindful of that, because I will tell you that I have been involved in statutory interpretation cases, and often my first step is I look at the legislative history. And when you saw Romy put up I have the same the aids in construction of ambiguous statutes. One of the reasons that I often look at the legislative history is the Ohio General Assembly has put forth in Revised Code 1.49 that's one of the considerations that a court is going to look at if a statute is ambiguous. The big thing there is if the statute is ambiguous. So with respect to the Maple Heights decision, that Justice Kennedy wrote her concurring opinion in, she was very focused on the text of the statute. And I am going to compare it a little bit to an earlier decision that I had involved in, where Justice Kennedy also happened to write a concurring opinion and a dissenting opinion. And it was from a couple of years prior to the Maple Heights decision, which is a 2022 case, as opposed to New Rigel, that was a 2019 case. I'll start with a caveat that it may simply have been that Justice Kennedy found the statute at issue in Maple Heights to be unambiguous versus the statute at issue in New Rigel. Perhaps she found it to be ambiguous, but I will tell you that she went through some of those factors that we see in 1.49, meaning she looked beyond the text of the statute to reason and discuss what she was critiquing about the majority's decision in New Rigel. Comparatively, in the Maple Heights case, the more recent case, she tailored it to the text of the statute alone and really took issue with going beyond the text of the statute. So I'm once again going to turn to Justice Kagan, because I will say that both Justice Kagan in this clip I'm going to play and Justice Kennedy in the New Rigel decision really sort of talked about the focus on the text of the statute that is at issue in your case really means the entire statute. So if in your case you have a particular provision of the statute that is key, you have to look at the entire statute and give meaning to every single word within that statute. Look at the way that the General Assembly used a word in a prior section of the statute to interpret how that word is now being utilized in the particular provision that you are suggesting to the court should be analyzed in a certain way.
Question, but you kind of sound like a textbook. Would you describe yourself as a textbook?
Yeah, I think I would. I think I'm pretty textualist. I'm very textualist in orientation. Now, I'll give you a couple of caveats to that, which I think honestly oughtn't to be caveats. I mean, it should be just things that people understand as part of the textualist enterprise. But because some people don't, I'll express them as caveats. And the first is that, I guess these are related, but is that to do textual interpretation is to look at a whole text, right? And I think everybody on the court does this, and we sometimes disagree about what this means and about the extent to do it, but I think everybody on the court recognizes that this is true, that even when the question is about what a single word means or what a single phrase means, that the way to figured out that question is not just to stare at that single word or phrase. You don't put blinders on.
Sure.
And when you do textual interpretation, you look at that phrase, but also many other phrases that share common features of the word or phrase that you're looking at. You look at the design and structure of the statute as a whole to see what the statute is trying to do and how this particular phrase fits with what the statute is doing. And so you look at content structure, and that's a critically important part of textualist interpretation, as I think people now sensibly do.
So, moving back to reference to legislative history, which is one of the factors that can be considered by courts when a statute is ambiguous for revised code 1.49, relying on legislative history to try to explain to a court that this is how a statute should be interpreted is not without controversy, and it's sort of a long-standing controversy. I know that we're talking that these are trends or these are new trends, but it's certainly something that has been controversial for a long time. I thought this quote was kind of cute, where Judge Harold Leventhal stated, "Legislative history is like looking over a crowd and picking out your friends." I will tell you that this is not a new quote. Judge Leventhal was succeeded by then Judge Ruth Bader Ginsburg on the U.S. Circuit Court for D.C., which tells you that this was a long time ago. And he was succeeded when he passed away, by the way. So we're talking, in the 70s. But so it's not like it's a brand new topic by any stretch of the imagination. But I will tell you, if you look at some of these recent decisions, it definitely is something that is being discussed. And when I say recent decisions, I refer again to that Maple Heights case, and then I'm going to talk about a Justice DeWine written majority opinion that is fairly recent as well on the topic. But I will go back then to my comparison of Justice Kennedy from 2019 to 2022, the New Rigel versus Maple Heights decision. And I will tell you, in New Rigel, she spent a considerable amount of time talking about the legislative history and the case law being supportive of the way that the statute was being interpreted, or how she felt that the statute at issue in New Rigel should have been interpreted. And I keep going back and forth to the juxtaposition with that Maple Heights case, because she was so fervent in saying you look at nothing other than the text, whereas just a couple years before, she really went into an analysis of several other things other than just the text itself. And as Justice Kagan is about to tell us, sometimes relying on legislative history goes too far.
So when we went to law school, I'll just read a quote from an opinion called Overton Park, which is a famous administrative law opinion. And this was from Overton Park, and it says, the legislative history is ambiguous. Because of this ambiguity, it is clear that we must look primarily to the statutes themselves to find legislative intent.
Exactly what that's such a great quote, because it expresses exactly this thing that I was trying to get at when I was talking about reading all these FOIA opinions. So that's how the opinions read,
Right.
which is really quite, it's like, oh God, we can't make a sense out of this story. The legislative history is all over the place. Guess we'll have to look at the text, and that's just not the way anybody.
I thought that was particularly funny, the way that she said it, but sometimes it's true, right? We as lawyers, we're looking at all these other things and trying to convince the court, and maybe you should look at the language of the statute itself. I will note, obviously, Justice Kagan is referencing Overton Park in that little section, but she also talks about the FOIA decisions. When she makes that reference, she's actually referring to her Milner versus Department of Navy case. And I thought there were a couple little sound bites from that case that are particularly relevant. And one in particular was, she talked about how in all of these FOIA decisions that she was reviewing, the courts were talking all around the statute, but missing and simply ignoring 12 simple words. And in her opinion, the 12 simple words that they were ignoring were the words necessary for the statutory interpretation. And all the other was just clutter and it shouldn't have been referenced. She also makes a quote, and to be honest with you, for whatever reason, I pulled the clip and it didn't make the video, where from the Milner decision, she says, and I'm paraphrasing, that ambiguous legislative history should not muddy clear statutory language. And so it just keeps coming back to the same theme. You have to have ambiguity in the text of that statute before you get elsewhere. And the court itself is going to look at the text if it is not an ambiguous statute. So just be mindful of that when you're preparing your briefs and when you're getting ready for oral argument, that if the text of the statute is there, clear, and unambiguous, that's what you should be really focusing on in your arguments. I am going to switch gears a little bit from legislative history to talk very briefly about a topic that is absolutely a trend in statutory interpretation right now. And if it wasn't brought up during this section, it would be definitely an oversight. And that is the question of deference to administrative agencies' interpretations of statutes. For those of you who don't practice in federal court, you may even be aware, just because it has made enough mainstream news, probably eggheady, nerdy appellate news, but it's still news nonetheless. The U.S. Supreme Court has accepted 2 cases for review dealing with the Chevron doctrine. And the Chevron doctrine comes from the Chevron case in 1984, so that's how long this doctrine has been in place, where the court stated that courts are required to defer to an administrative agency's reasonable interpretation of an ambiguous statute. So Chevron's been in place so long that even though it is federally minded, if you did a Westlaw or Lexis search and narrowed it to Ohio, you are going to find references to the Chevron doctrine in cases both at the intermediate appellate level and at the Ohio Supreme Court. And perhaps because of that, because there seemed to be a somewhat of an unofficial adoption of the Chevron doctrine in Ohio in certain cases, the Ohio Supreme Court recently addressed that issue in CWRU Enterprises. And in that decision, Justice DeWine and the majority, he wrote it, but the majority unequivocally stated that there is no mandatory deference to administrative agencies' interpretations of statutes. So it was a very explicit rejection of the Chevron doctrine. I believe that that's where the trend is heading. I mean, I'm not alone on that belief. There's a reason that the U.S. Supreme Court has accepted 2 cases on this very topic. So that is one to watch if you're interested in that type of thing. Relentless versus the Department of Commerce and Lawford Wright Enterprises versus Raimondo are the two U.S. Supreme Court cases that are going to deal with this particular issue. Again, with respect to revised code 1.49, I would not have thought of that to be a particularly controversial revised code section, but Justice DeWine in his decision actually said that one might question the authority of the General Assembly to tell the judiciary how to engage in its interpretive function. So he took issue with the fact that, I mean, I don't even know, that revised code section has been in place for a while. I probably, for today's purposes, should have looked that up. But it's just funny that type of what I kind of look at as an uncontroversial revised code section is a matter of some question. And I think the primary issue there is Justice DeWine was really talking about how there is separation between the various branches of government, and it is within the judicial purview to interpret the statutes of the Ohio General Assembly, and they should be able to do so as they see fit. But to bring the TWISM issue and the Chevron issue sort of back into where we started in terms of our discussion today, Justice DeWine reinforces the textualist approach to statutory interpretation and states, to start, an administrative interpretation should never be used to alter the meaning of clear text. If the text is unambiguous, the court should stop right there. And that just, again, I can't reiterate that enough. I know I'm being repetitive here, but it definitely is something to be mindful of as you are working on your appellate cases that deal with statutory interpretation. I just have a little punch list of very simple facts or very simple practice points. When you are faced with statutory interpretation cases, make sure that you look to see what the judges or the justices, if you're at the Ohio Supreme Court level, but at the appellate level, read some of their cases on statutory interpretation, even if the statute at issue in that case has nothing to do with the statute that you are arguing should be interpreted one way or another, because it's going to give you a flavor as to how that particular judge is approaching the issue. There may be judges who quite often are going to refer to legislative history or the other factors that are talked about in 1.49. Or there may be judges like Justice Kennedy and Justice DeWine who feel very strongly about textualism in their cases. Also be mindful of the currentness of the case that you're looking at for whatever judge or justice that you are reviewing, because like I said, although there may be other factors in play with respect to Justice Kennedy's decision in Rival in 2019 to her decision in 2022, there seemed to be a bit of a change. She seemed to have, a little bit of evolution there as to how she approached statutory interpretation. In other words, take a common sense approach. And with that, I'm going to let Justice Kagan finish up for us on that point.
Is that I like to think that, that textualism involves some amount of common sense, which is to say that, if your understanding of some word or phrase would produce some result that seems pretty nuts, and nuts in the context of the statute, mostly is what I mean. Then you should just ask yourself whether you're appropriately looking at it.
Thank you. I'm going to turn things over to Dean.
Right, thank you. My name is Dan Van. I'm an assistant prosecutor for Cuyahoga County. I appreciate the invitation to present here today on this panel, and I am also here to guarantee to all future lawyers and aspiring Ohio Supreme Court advocates that statutory interpretation is where it's at. Forget constitutional arguments, forget all that. Statutory interpretation, that's kind of a big part of what the Ohio Supreme Court does as far as its own litigation. I think as far as my own experience, pretty much a majority of my cases that have gone up to the Ohio Supreme Court have involved some element of statutory interpretation. Now, when we were preparing for our panel discussion, and Eric and I were talking about how we wanted to approach this. One thing did stick out to me as far as pivoting from Justice Kagan. Told Erica, there's this one case that you just have to listen to on the topic of statutory interpretation. So, typically, we don't deal with federal statutes, but I think it is an illustrative case of statutory interpretation and plain meaning.
So, and Dan's right. To give a little bit of context, the case is Wooden versus United States, and what happened here was under the Armed Career Criminal Act, which I will hereafter call the ACCA. The court, it's 924(b)(1), but the court must impose a 15-year minimum sentence for unlawful gun possession where the offender has 3 or more prior violent felonies. In this case, there was no dispute that burglary was a violent felony. But the question, the violent felonies have to be committed on occasions different from one another. And so the court was asked to decide in Wooden what the words committed on occasions different from one another meant. And so a little bit of background. So Wooden was found guilty of being a felon in possession. Under the Act, he has to do a 15-year minimum sentence. It's 15 years to oblige actions. For that offense, if he has more than 3 prior felonies, violent felonies. But those felonies need to be committed on different occasions. Wooden appealed. The lower courts said the occasions clause, the Act's occasions clause is satisfied whenever crimes take place at different moments in time, sequentially rather than simultaneously. So the government was looking for a rule that said an occasion happens at a particular point in time, the moment when an offense's elements are established. Wooden, on the other hand, maintained that he broke into a single storage building and seriatim broke into individual storage containers. So basically he hit 10 of them. He was convicted of 10 separate burglaries in a single indictment. But it was all on one occasion. So at the oral argument, there was very little basic argument made by either party. And most of it was just questions and hypotheticals. And so Dan had the wherewithal to cut the transcript. And some of the hypotheticals are just, I mean, the questioning was wonderful. I will ultimately say that Justice Kagan, our textualist, she authored the opinion, and it was clear she was really running the argument, as it felt, at least from my perspective. But I think that Dan should share some of the hypotheticals.
Sure. This is a more recent U.S. Supreme Court argument, so it was under its new format where the litigant or advocate gets to give opening remarks and then proceed to be grilled by each and every justice of the United States Supreme Court. So that does also mean that we have heard a lot more from Justice Thomas. But I think I'm going to highlight a few points. I think kind of what sticks out is from the advocate's perspective when you're advocating a position. I think what the justices were really trying to nail down is, under the advocate's interpretation of the statute, how far does that go? How does that play in different circumstances? So the attorney for Mr. Wooden makes an argument, and he uses different phrases to kind of describe the definition of an occasion. He describes it as an episode or opportunities. And so you can imagine when you're an advocate and you're replacing the word opportunity with or occasion with opportunity or episode, you know, what does that mean? You know, in response to the opening remarks, you know, Justice Thomas asked Mr. Wooden's attorney, well, you know, could what if, and you know, the circumstance being a string of events, in this case, it was breaking into the storage locker, breaking into the various units. So it was asked, well, what if they took a smoke break? What if they decided to have lunch? Well, what if, let's say, we've got time, we can go to Starbucks, grab a cup of coffee. Forget Starbucks, Dunkin' Donuts, get a cup or two. I mean, they stay for an hour. And what I was trying to convey is, where's the limit? Because, you know, that type of situation is describing a break. Now, we talk about now Justice Alito had started to really ask about the attorney's use of the term criminal opportunity. Fair question. You use the term criminal opportunity. I have no idea what a criminal opportunity is. I mean, let me give you some examples. A street light goes out and a mugger says, aha, this is a criminal opportunity. I want people who walk by here at night. And that person does that at 10 at night, 11 at night, midnight. Is that one criminal opportunity or three? Now, Mr. Wooden's attorney responds, that sounds to me like the same episode and opportunity. And, you know, they start talking about breaks. Well, what does clean break mean? Justice Alito asks, well, let me just ask you one more question. I'll stop. Say a clean break. Why is it a clean break? And so, you know, I think you can kind of, like, listening to this, like the oral argument, you can kind of really see how the justices were challenging the attorney for Mr. Wooden on how he was understanding, you know, that phrase, occasions, different from one another. Chief Justice Roberts plays off of Alito's hypotheticals about the street light. Yes, counsel, going back to Justice Alito's hypothetical about the street light, if I understood your answer right, you're saying that the street light goes out and the individual thinks this is a great opportunity to mug people, and he lies there and mugs person after person. You call that one occasion, right? Attorney response, that's correct. Changing it up. Well, what if what makes it dark is that it's a moonless night? He says the moon is not out tonight, it's dark. I can mug person after person. One occasion or multiple occasions. So I you know, I think we could do an entire presentation, do an entire play-by-play commentary on this oral argument. You know, if you haven't heard of the case before and interested, I think it is kind of a very fascinating oral argument to listen to. I think the end result in this case, what when we're talking about the plain meaning, ultimately, you know, the U.S. Supreme Court, it's a unanimous decision as far as an occasion. Yeah, and you know, I think kind of paragraph kind of sticks out in the opinion from Justice Kagan. Read. Well, consider first how an ordinary person, a reporter, a police officer, yes, even a lawyer, might describe Wooden's 10 burglaries, and how she would not. The observer might say on one occasion Wooden burglarized 10 units in a storage facility. By contrast, she would never say on 10 occasions Wooden burglarized a unit in the facility, nor would she say anything like on a third occasion he burglarized yet another, and so on. She would using language in a normal way group his entries into the storage unit, even though not simultaneous, altogether is happening on one single occasion. So, you know, it's like I said, this statutory interpretation is where it's at. So it went all the way to the U.S. Supreme Court.
Just a couple more, words on Wooden. So as far as statutory construction is concerned, the court, in Justice Hagan's, opinion, she noted that the construction that the government wanted, equating occasion with an offense, and if you look at the ACCA, they use both independently. And so that again, we're looking at the direct language of the statute. The court then looked to the ordinary meaning of the word occasion. One of the hypotheticals, was Tony Barrett talking about a wedding and how a wedding from the ceremony all the way to the reception to the end is a single occasion, but there are multiple incidents going on there. So reflecting that idea of the ordinary use of the word. And the timing between the occasions, that's a factor. And then they look at the ACCA's history and purpose. And ultimately, what the court concluded was that this is going to be a factually dense analysis. It is practicality of the circumstances. They didn't want to do that switchy. But the bottom line is occasion, in this case, it was a single occasion. Multiple offenses get a single occasion. So moving on to the Ohio Supreme Court. State versus Williams, which came out earlier this year, the General Assembly was asked, the court was asked to determine what the General Assembly meant when it used the term causes to be delivered under 2941-401. That provision triggers the 180-day speedy trial clock to start running when the defendant, the inmate, causes to be delivered to the prosecuting attorney in the appropriate court notice of his location of imprisonment and a request for final disposition. So that starts the clock running while he's locked up, even if he's not necessarily available to be in court. But the statute also says that the prisoner must give or send a written notice of his location request for final disposition to the warden or superintendent having custody. The statute also says the warden shall then promptly forward that notice to the appropriate court. So in this case, the defendant ended up at Lorraine Correctional, and he learned he had a case pending in Lorraine County Court. And so he sent notice to his warden 3 times on 3 different occasions. And then at that point, he moved on and went to Richland and served out the balance of the sentence. But what had happened was the warden didn't ever forward any of those notices onto the courts. So the case ended up in the Ohio Supreme Court, and the state argued that 2941-401 is unambiguous and should be by as written. The inmate did not ultimately cause the notice to be delivered because of the intermediate steps, but he did cause the notice to be delivered, so he's out of luck.
If I may, Erica, that sounds awfully similar to the requirement under Appellate Rule 10A that the appellant is responsible for the transmission of the record, which the appellant has very little actual practical ability to achieve. So this concept of somebody else having to do a job that you initiate is a problem perpetually in many cases.
Sure, the only thing I distinguish is that that's a rule, which is procedural. And I'm not sure how those interplay, but absolutely. So this guy doesn't have any control over his situation, and he did what he could do. So this decision, and the oral argument is not as entertaining because the dissenters said nothing. So it's not clear where they were headed. But in this case, the majority said the inmate meets the causes to be delivered requirement under 2941-401 when he provides a written notice to the place of imprisonment and a request for final disposition of the warden of the institution where he's locked up. The dissent, each is written by him, says it's self-evident that he didn't cause to be delivered the notice. He didn't meet that standard, therefore he's out of luck.
Yeah, I think I would just offer a few things. First of all, I think the decision in this case was pretty consistent with the status of the law in the 8th district. But one thing that kind of sticks out from this opinion is that it was a split decision, and both the majority and the dissent purport to be looking at the plain meaning of the statute, and they came to different conclusions. It was, we mentioned before about the revised code 1.49. Obviously, that's the revised code indicates that that's our first step. We have to look at whether a statute is plain, whether it's unambiguous before moving into those other interpretive methods. Now, where Justice DeWine wrote the dissent, and kind of I'll read off one paragraph here, paragraph 24 of the opinion in the dissent. He did look at the dictionary, which is a one method to get to the plain meaning, but kind of going off of this, well, how does an ordinary person understand this meaning? We saw that in the Wooden decision. What he indicates in paragraph 24 that writes, but of course we don't need a dictionary to understand the majority's reading of 2941.401 is at odds with its plain meaning. No ordinary speaker of the English language would say that someone caused a war if war was averted, and no one would say that the mixture of two chemicals caused a reaction if a reaction didn't result. And so, I think in that context, when he was applying it to the statute, this is a statute about intra-state detainers when the speedy trial starts. He was using that understanding of cause to be delivered. That's reading to me, because it wasn't delivered, it was, the defendant in that case could not have caused it to be delivered within the meaning of the statute. So, it is an interesting take, interesting look at how we can come to different conclusions about the plain meaning of a statute.
So I would be remiss if I didn't talk about a decision out of this court. State versus J. Logan. And I'm gonna gloss over the torture procedure history. Suffice to say, this case ended up being decided in an ongoing decision. And the question there was, does 29-29-13 F8 bar the court from imposing a term of community control sanction on a felony that underlies a firearm specification? And Tosh, I'll give you a shout out here. So the state argued there that if there is a firearm specification imposed on a case, then the court must impose a prison term on the underlying felony. The state is repeatedly calling the prison term on the underlying felony mandatory, and I think it's a term of art, but I'm confused in that context precisely what the prosecution means when they talk about the mandatory nature of the underlying offense. Anyhow, so noting an inter-district conflict, the on-bound court took the case, and 8 members of this court held that, and if I get this wrong, I'm sorry, I'm paraphrasing, held that 29-29-13 F8 does not require the imposition of a mandatory prison term or preclude the imposition of community control on the underlying felony when the defendant is found guilty of that felony and the sentence on the corresponding firearm specification. So a 3-year term, mandatory term in the firearm specification followed by a community control sanction is okay. The majority also looked to the rule of lenity and said, F8, 2013 F8 can't be read in any other way than we do here. Even if there were some ambiguity, sections of the revised code defining the offenses or penalties should be strictly construed against the state and liberally construed. Citing 2901.04A, which is the rule of lenity, which is a rule of statutory construction. The court looked at the language, mindful that the courts can't add or delete words. And so section F lists the provisions requiring the court to impose prison terms limiting how imposed sentence may be reduced. Part A includes the consecutive sentences imposed under 29-14A for firearm specifications. Since Part A explicitly tethers the mandatory portion of the sentence to that imposed under 29-29A, which is the firearm specification time, the General Assembly did not intend to require a prison sentence on the underlying. In this case, the underlying felony was having a in the switch. To read it otherwise, we then read out some of the section in Part A, Part 8. The range of justices, there were 4 of them, concurred and agreeing with the result, but issued a separate opinion. Noting that the plain language of 29-29-15 does not require the imposition of a prison on an underlying offense. But that doesn't mean that there are not other ways to do that in other sections of the revised code. And basically the concurrence noted that all this law has become really, really unclear and unwieldy, and the proper help to the Alliance Supreme Court. So please provide some guidance on that. And the state of sense, I mean, there's a motion to certify a conflict. They noted the conflict below. And we think the case pending in the House before. There's little doubt that they'll resolve this question in one fashion or another.
Right, I won't offer too many remarks on that. It is a pending case, and talk to Porciano from our offices handling that case, and I do hope the case gets in. Just kind of a quick practitioner point. The state did file a memo in support of jurisdictional appeal in that case, as well as a notice of certified conflict. I always think it's a good idea to file the MSJ in addition. Just you get some extra words to explain the conflict. Now, when I think about the pool of cases and statutes out in Ohio law, I think the Allied Defense Statute is kind of one statute that's been subject to interpretation time and time again. So I think we've had quite a bit of different iterations of how the Ohio Supreme Court has interpreted that rule. I do think it's biased opinion, but I do think the most current iteration is most consistent with the text of the Allied Defense Statute. So those of you who are not familiar, I'm not going to read the entire statute on the screen there, but in Ohio law under the Allied Defense Statute, when you have certain offenses that meet certain criteria, they emerge under the statute. What the statute looks at is whether you have the same offense. It looks at whether you have the offenses are a similar import, whether or not the offenses share an animus. So, there are a lot of words up there on that screen that are subject to interpretation. Well, what does each and every one of these terms mean? And so, we for the most part, I think we've seen the statute in criminal cases in Ohio Supreme Court applied in different contexts. State versus Logan was one of the earlier cases, and it's a typically cited case in determining whether or not a rape offense merges with a kidnapping offense. I think interesting thing about the statute here itself is that if you really look at the opinion, aside from the fact pattern, it's what the Ohio Supreme Court indicated they were looking at this case is to determine whether or not the rape offense was committed with the same animus as the rape and kidnapping were committed with the same animus. So it does, throughout the opinion, engage in a bit of an analysis, and it sets up a test. And the results in which the Ohio Supreme Court held that the rape and kidnapping offense merged under the same canvas was kind of surprising. Just having to read the opinion and the court starts explaining about like victims, and you realize that under the facts of the case that you had a victim who was moved from an alleyway into a building, and then you get the result. It's kind of surprising, but I thought what was interesting about this case in and of itself was again the fact that when the court was looking at this case itself, it purported to only look at the animate portion. It didn't really define allied defense statute itself. Actually, interestingly, looked to understand the meaning of kidnapping and looking at how other states define kidnapping to understand whether or not that offense shared the same animus as the rape offense. Now, I mentioned that the most current iteration of the allied defense statute is State versus Ruff. So kind of in between Logan and Ruff, we had quite a few different cases out of the Ohio Supreme Court. We had the Rance case that talked about doing an abstract comparison of the offenses of the statute. We had State versus Brown, which talked about looking at the societal interests sought to be protected. And just prior to Ruff, the Ohio Supreme Court had decided a case, State versus Johnson. And what the syllabus had indicated in that case was that it was overruling Rance, and that the test in that case, or as applied to Johnson, this was a case of a felony murder which predicated upon a child endangering, indicated that the court was to look at look at the conduct of the offender. So of course the defense argument in that case was, well, I just engaged in one conduct that also, that unfortunately resulted in the death of the victim. So there was not a majority opinion in that case, but the court did end up merging those two offenses. Now we, kind of fast forward to Ruff, and I think Ruff is kind of significant because it did acknowledge how its test in Johnson was incomplete. What the court ended up indicating in Ruff is that we do look at things other than conduct in and of itself. So we do look at animus on other things. I have just a couple of additional slides here in the material that kind of go through the case. One significant thing that the court has indicated in helping us to understand whether offenses are of the similar import, looking at whether or not there was separate and identifiable harm among each victim. Having kind of helped work on this case, our office made additional amicus briefing in that case. I think, one thing we were conveying is that that we're trying to do is just go back to the allied defense statute in and of itself, kind of break it down each provision, because for a time, it seemed that courts across Ohio were really just looking at the conduct and not looking at those other things that the statute indicates that we should look at. State versus Early is another allied defense case, and I'm just gonna briefly mention that this actually involved interpretation of two different statutes. Again, this Early had been decided kind of following Ruff, but throughout the appellate process, as this was going up through the 8th District Court of Appeals, State versus Johnson was case law, and that was courts were applying it. This was a case involving an aggravated assault, predicated upon an OBI. So of course, following the Johnson case, the defense argument was that the two offenses merged because of it was one conduct. Now, admittedly, in a prior case under the Johnson framework, our office, we had conceded the issue. The issue was conceded in another case, so we were dealt with precedent, indicating that these two were subject to murder. So when we were litigating this case up to, I wasn't directly involved in this case, but as the case was being litigated up through the district, we did manage to identify a particular statute under 2941 that did indicate that the court could impose separate sentences for an OBI offense and particular assault. So, I guess I kind of say that for two parts. It's very easy to just stick to the case law. Oh, well, this case law says this, so this is the test. But, it's always going to be important to just go back to the statute. What does the statute mean? Is there another statute that might apply in a certain case? I don't think it, we managed to identify the provisions under 2941 that this case would have gone all the way to the House Supreme Court. I think it's certainly go through the procedural history of early, kind of where we were at with allied defense case law. I just got to say, always go back to the statute. Always try to understand what the statute means. Is this case still applicable? Is it missing?
Just one last case, but I want to finish up the allied defense discussion by saying is, as much as the court's written on this issue, I still go with the I know it when I see it kind of gut feeling. And I don't think they're done right at all. And so with this, the last case is State versus Bertram, which also came out just earlier this year. Interestingly, it was they issued the opinion 2 weeks after the oral argument. And the question there was, what did the General Assembly mean when terms trespass by force, stealth, or deception under that portion of their rules, which is RC 2911-12-82. That case, the defendant had walked into somebody's garage, picked up a leaf blower, and walked it back to his car. And as he was going to the car, the owner of the leaf blower in the garage said, "Hey, stop it, bring the staff." And he just looked at him and kept going, loaded the leaf blower into the car and drove away. And so he was prosecuted for burglary, and the judge sentenced him to an 8 to 12 year sentence and added additional time for the violation of post-relief control. So the case ended up in the Ohio Supreme Court, and the defendant argued that while he did trespass on the property, there was no proof that he had done so by force, stealth, or deception. And the court looked at the language. Clearly, there was no force here. They said to get out of the way. And the question was, where's the stealth and the deception? They looked at the dictionary version of stealth and the statutory definition of deception, and they concluded that to prove trespass, you have to have that the trespasser actively avoided discovery or used deceptive conduct to gain entrance into the stuff. The prosecutor had argued that he was cavalier and engaged in sly behavior, and the court was having none of it. And if you watch the oral argument, it's wonderful because the entire court, all 7 of them, are laughing. And then you have to the person said, "No, that's not what you have here." And so sometimes plain meaning relieves plain. That's the problem.
Thank you. In listening to your discussion, it sounds like differentiation is some kind of issues that you were describing with respect to recurrence. I'm sure Colleen can verify that happens, it comes up a lot in the insurance industry, because many insurance contracts use the term recurrence. And I think I remember that the 9/11 litigation, there was a lot of litigation about whether the 9/11 litigation was one occurrence or multiple occurrences for each of the 4 separate attacks. So very interesting. All right. Okay, so thanks, Eric. My discussion is about the inconvenient truth that at times, even though we might look at a statute and conclude, or even not just a statute, I'm going to talk about the Constitution as well. And even though we might conclude that a particular piece of text has a plain meaning, there is a hostility toward applying that plain meaning in a way that feels wrong, inconvenient, impractical. And so I'm going to briefly just reference again the absurd result principle that Rami and Colleen both mentioned. That's ingrained in Ohio law as a matter of common law doctrine, although the statute that they also talked about, one could argue, is just a manifestation or a codification of parts of it. So the 4 things that we presume in the statute are compliance with the Constitution of the state and the United States. Can you lower that a little more, Mr. Collins? Okay, so the 4 things are the compliance with the Constitution. The entire statute is intended to be effective, which dovetails with some of what Justice Kagan was saying about how we don't just isolate particular words that we're caring about in a particular moment. And this is the part that I think is most consonant with the absurdity doctrine. The just and reasonable result is intended. And then this last one is also really key, whether the result is feasible in terms of execution of the result. What I don't quite understand about 1.47 is whether this presumption is a tool that we are supposed to use in construing plain language, or whether it is a justification for disregarding plain language if the plain language does not comport with one of these 4. Or maybe somewhere in between. In other words, it presumptively comports, but if a party challenging a particular interpretation that feels plain languagey can demonstrate that it actually does not reach one of these 4 principles, then maybe you can overcome the presumption. And one of my former evidence students is here in the room, so she knows all about presumptions that are in a different context. We don't handle them quite the same way, but it is a little fuzzy to me how this really manifests itself. And the one interesting thing that I have not found any case law that actually helps us make this, harmonize this with what we typically think of as an ordinary plain error or a plain language review. So what I'm going to do now in the time that I have left is give you 3 different examples of times when the plain language, for whatever reason, doesn't actually mean what you think that it means. And then if there's time at the end, I'll also talk about the Supreme Court's recent reconsideration decision in Wynn, which is about a particular consecutive sentencing statute appellate review. And if time allows, we'll talk about that too, because it's very interesting. So the first example. Shall actually means should. So this particular statute, and it's just an example, is a statute that applies to dispositional hearings in juvenile court. And this particular statute has a provision that says that the court shall enter its judgment within 7 days of the conclusion of the dispositional hearing. So what do y'all think that means? What happens if it's the 8th day and there's no judgment? Well, in the KM case, the Supreme Court decided in 2020, they reiterated a principle that is actually not a new one, but that principle is that shall does not always require the action in question. In certain circumstances, even when the statute contains the word shall, we have construed a statutory time limit as directory so far as the performance is concerned. So, what does directory mean? The age group of this audience will be revealed in a moment, because when I think of directory, my mind goes here. And this is what happened to all of them. Landfill somewhere. Telephone directories actually used to be the way that we learned how to reach a particular person, both address and phone number. And they would be delivered every 6 or 12 months. And you'd find them on your front doorstep, and you have to figure out which phone to put it near, because you only got one white page, one yellow page. Anyway, that's not what this is about. This directory actually, according to Black's Law Dictionary, means that the directive in question has no obligatory force. And so that's fine. I can live with a word that means something different from what it sounds like it means, because if I'm directed to do something, I don't generally think I have a choice about the matter. But apparently, the word directory means you do have a choice about the matter, which means that it seems like a really good opportunity to use the auxiliary verb should rather than the auxiliary verb shall, because shall does mean mandatory. And all over the jurisprudence of the state, you'll see that language. Only when it's an exception like this do they then pull back from it and recognize this concept of directory. And apparently the concept of directory is a well-established exception to the meaning of the word shall whenever you are talking about a period of time by which a public officer must act in order to comply with whatever the statute says the officer has to comply with. So apparently public officers performing some function with the time component don't really have to abide by the time component unless you can find something else in the statute that might make that time component more of a crucial component of the obligation. So that's probably where things like time is of the essence clauses come in contracts, because otherwise there is a risk, even outside the public duty context, that time doesn't really mean what it says. All right. Here is another example, though, that does not involve time. This particular statute, 2838.11F, has a time component to it, but it also requires that after a jury verdict or a bench trial, the decision will be announced in open court. You have to announce your verdict or your decision in open court. It's so basic that you probably didn't even expect there to be a statute about it, because it's sort of a constitutional component or ideal as well. Nevertheless, thank you, 8th District in 1998, there is not a single judge, I don't think, who was on the court in 1998, and he's still on the court now, so I can criticize this decision. But the 8th District literally said that this particular provision, despite the use of the word shall, is just a guideline suggested by the legislature, okay? And so what really irks me about this whole problem is that we don't have good contours. If you want to say that public officers don't need to do their jobs within statutory prescribed timeframes, fine, at least you can agree or disagree with the principle, but at least that is a construed, contoured doctrine that courts can apply. This, that you don't actually have to announce a verdict in open court, feels a little bit first of all, outside that contour, but also it feels groundless. On what basis then do we decide when shall means shall and when shall actually means, oh, it's just a suggestion? And if you think that this does not have serious consequences, then take a look at Ohio Constitution, Article 2, Section 15B, also known as the one subject rule. Perhaps you're familiar with the one subject rule. Those of you who've been around since the 90s might remember the Seward case, which I think struck down one of the tort reform efforts, I think in part because of a violation of the one subject rule. It might surprise you to know that for most of its life, this provision and the predecessor in the earlier version of the Constitution was considered directory. And so there was no mechanism in the court system for enforcing this constitutional provision. At some point in the mid-20th century, and I didn't do my research to figure out exactly when, but at some point that changed. And the courts now enjoy the power to invalidate a statute if it violates the one subject rule. That's the rule now. But 3 justices, including Chief Justice Kennedy, think it ought to be reverted back. And that holding, which was in 2018, I believe, was obviously at a time when the court was differently comprised. And so there is some reason to believe, if you construe this deference to the legislature as being a more, let's say, conservative judicial philosophy, that we are not that far away from the time when, once again, the one subject rule that is enshrined in our Constitution has only the enforcement mechanism that the other legislators are willing to give it. So this really could have significant consequences, this should-shall distinction that go beyond things like, how long it takes the trial court to issue a decision. All right, that's the end of example 1. Example 2. The final actually means, so those of you who have heard me speak on final appealable orders know my shtick about this. But basically, the Constitution, Article 4, Section 6, 1912 says that the courts of appeals, this is actually the earlier version, the penultimate version, courts of appeals have jurisdiction over judgments of courts of appeals as may be provided by law. So the Constitution says, General Assembly, you decide what the courts of appeals can hear. But one limitation is it has to be a judgment, they said, back in 1912. In 1912, a judgment was a final determination of the rights and the parties in the action. And so the code, as of 1912, actually said, very much like what our current version of 250502 B1 says, that if it determines the action and prevents a judgment, it can be appealed. But fast forward to 1937, they added a new provision to it's a different code section, but it's otherwise the same. All of a sudden now in 1937, the legislature said that you can appeal as a final order, an order from the trial court that vacates or sets aside a jury verdict. All of a sudden now we have this new provision for the very first time that seeks to enhance or expand Ohio appellate jurisdiction beyond the traditional final determination of the rights and the parties of the action. And what did the Supreme Court say? No. The attempt to make the setting aside of a verdict and the granting of new trial a final order not only goes beyond the reasonable limits and violates the Constitution, but if approved, would by inference withdraw all limitation against future enlargement of the jurisdiction of the Court of Appeals by legislative enactment. So the Constitution wins. And they also went on to say that if the people want to, the way to do this is through a constitutional amendment, which is exactly what the people did. On November 7th, 1944, the word final orders was added to the constitutional section. By the way, something else was sort of going on at the same time. So I've always found it interesting that you care enough about appellate jurisdiction to put rules under this right in the middle of the. That's another day. All right, so what happens? 1951, even with this amendment, the Supreme Court says no dice. An order granting a new trial is not a judgment or final order and cannot be made so by legislative enact. So once again, the Constitution wins, even the new version of it. Not good enough to give the General Assembly the power to expand. That decision in 1951 lasted 14 years, where the same court with the same constitutional provision finally relented and said, all right, we'll give it to you. An order that grants a new trial is a final order after all. Okay? So right there, we have this, we haven't really talked specifically about what we all think a final order is. And maybe you can satisfy yourself, as the Green Court did, as the Price Court did, maybe you can satisfy yourself that this is in fact final, because we went through a whole trial already and now we're undoing it. And even though it means that we still have to have a trial, it just feels wrong not to conclude something. Fine. But Chief Justice Taft in that same decision cautioned us. Oh, so they can live in harmony, that's the point. Chief Justice Taft cautioned us, I didn't attribute this to him, but it is his concurring opinion. I do not interpret our decision today as indicating that the General Assembly may make an interlocutory order appealable by calling it a judgment or final order, or by including it in the definition of judgment. In other words, if you're going to say it's a duck, it has to quack, and some things aren't going to quack. That takes us to, oh, there goes that part. That takes us to our current version of the statute, 250502B3, which has the provision there about a new trial that we finally in 1965 can consider final. But in 1998, the provisional remedy section of 250502 was added by amendment. And if you're not familiar with it, a provisional remedy is an appeal. If you meet the requirements, which requires it has to be a provisional remedy, which is a whole bunch of things, including, let's say, a preliminary injunction for the sake of ease. And if it is a preliminary injunction and it meets the two subsections of 250502B4, then it is considered final. That's the date, the nomenclature. It is a final order, and the appeals court can hear an appeal from it. So in my mind, a preliminary injunction is not a final order, unless it's so complete that it essentially moots the rest of the case. That can happen. But just for reference, the same order in the federal system, which is also appealable, is appealable under 1292A1, which defines interlocutory orders that may be appealed. So in the federal system, a preliminary injunction is an interlocutory order, the opposite of final. But in order to facilitate appellate review of things like preliminary injunctions and discovery of privilege matter, where we really feel like rights will be lost if we don't allow the appeal now, the General Assembly has said it's final. And under the Price case, depending on which way you go, if you go with Chief Justice Taft's concurring opinion, there is room for doubt about that. There is room to argue that that particular provision of the Ohio Constitution, of the 250504, is in conflict with the Ohio Constitution. Reminding you again what Chief Justice Taft said in Price versus Clinton. So I see that we're at the end of the session. You want me to finish it up? Okay, finish it up real quick. Maybe not so real quick, but I'll try. So here's the third example. When final actually doesn't mean appealing. So this is sort of the inverse of what I just talked about, where we have slapped the definition of final of things that don't feel really truly final. And this comes up in the context of Civil Rule 54B, which we don't have time to go over in any depth. But essentially, the rule says that the court can enter partial final judgment on a subset of the claims that have been resolved. And the reason for the Kit Kat bar is, if you've gone through this presentation with me when we're talking about actual appellate jurisdiction, I use Kit Kat bars as an illustration of how a 54B determination can be proper. It has to be at the joint. You've got to score in the middle rather than just certifying anything you want to. It's got to be a discrete claim. In the Wissentainer case in 1993, the Supreme Court admonished us not to put 54B language on something that does not resolve a discrete claim. That's the basic point. It doesn't transform a non-final order, the court said, into a final order. He said what it does, the court said what it does is it transforms a final order into a final appealable order. Okay. So first of all, I disagree with the first part. The thing that 54B does very definitively is takes a non-final order that wouldn't be appealable without the 54B because it's not final and renders it final by slapping that 54B certification on it, breaking it off from the rest of the case and sending it up for appellate review. The corollary then is that it doesn't transform a final order into a final appealable order because there is nothing in the Constitution or even the statutes of the state of Ohio that distinguishes between a final order and a final appealable order. In fact, if you go to the current version of the Constitution, the legislature gets to decide what's final. It doesn't say appealable. And if you look at what the legislature has chosen to do, which I guess we're not going to do. There it goes. Every final order is appealable. Not just those that somehow have an appealable attachment to them. So this Wissentainer nomenclature, although it is characterizing a concept that we're familiar with, which is the notion that not every order can be appealed, the language that it uses to differentiate between those that can and those that can't, to me, has only made the situation more confusing for litigants. And that confusion is all the more rampant because this language from Wissentainer is picked up again and again and again and again by every district court of appeals. So the plain language is easy enough in this case. It's easy, it's convenient, and it doesn't create any problems in terms of the Constitution, practical or whatever. But still, we are rewriting the statutes to fit with our conception of how the jurisdictional system should work. So I finished just on time. If you want to talk about Gwen, I'm happy to do that, but not officially now.
Well, right now, not officially now. So right now, it's time to take a break, to go pick up your lunches.